Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. Ever since its inception, IBC has been a great learning experience for all of us. I welcome you to Insolvency Insights, a snippet series curated by me, to delve into important judicial pronouncements under the IBC, which is now reshaping the economic landscape of our country. So let us discuss one landmark case today. So this is the case of Moser Baer Karamchari Union versus the Union of India and others, which was decided on the 2nd of May 2023 by the Honorable Supreme Court of India. Now, in the case of Moser Baer Karamchari Union, through its president, Mahesh Chand Sharma and others, versus the Union of India, the court has refused to interfere with the waterfall mechanism in the IBC Code 2016, which it categorized as an economic legislation. The judgment has settled the tussle between Companies Act 2013 and Section 53 of the IBC, both of which hold significant implications for stakeholders in the corporate and insolvency landscapes. Now let us see the factual background of the case. In the Moser Baer case, the constitutional validity of Section 327(7) of the Companies Act 2013 was challenged because it was an overriding provision that cancelled the effects of Section 326 and 327 when kicked in. Section 326 and 327 would not apply at the time of liquidation in Section 53 of IBC would, and that proposes a waterfall mechanism which proposes a different order of priority for distribution of proceeds. Now, according to Sections 326 and 327, payments of workers' dues, revenues, taxes, and cesses due to the union would have had priority. But under Section 53, the order of priority is secured financial creditors, unsecured financial creditors, government dues, and finally operational dues. In this case, workers' dues come under operational creditors. Now, let us understand Section 327(7) of the Companies Act 2013. Preferential payments are made in a winding up in accordance with the Act's provisions enumerated in Sections 326 and 327. These include the workers' dues, earnings, taxes, and cesses that the business owes to the union, a state, or a municipal government. However, according to the Insolvency and Bankruptcy Code 2016, distribution must be done in accordance with Section 53 of the IBC in cases of liquidation under the IBC. The Companies Act of 2013 was amended to provide subsection 7 of Section 327, and that Sections 326 and 327 of the Act 2013 will not be applicable in the event of liquidation under the IBC in light of the ratification of the IBC and Section 53 of the IBC. The said amendment was brought in order to avoid any friction or inconsistency with the IBC. Now let us see the scope of Section 53 of IBC and the waterfall mechanism. The order of priority for receiving the proceeds from the sale of liquidation assets is laid forth in Section 53 of the IBC, which has the effect of superseding all other provisions because it is a non-obstante clause. Now, this gives priority to the costs of the bankruptcy resolution procedure and liquidation. Workmen's wages and obligations owed to a secured creditor are paid after them, both equally. The waterfall mechanism refers to the precedence hierarchy. Secured financial creditors are given the greatest priority under the waterfall process. Following them are unsecured financial creditors, governmental obligations, and then operational creditors. Now, what is the conflict between Section 53 and Section 326 and 327? The conflict arises when we consider the contrasting treatment of workers' dues under Section 326 and 327 of the Companies Act and Section 53 of the IBC. The Companies Act provisions, namely Section 326 and 327, acknowledge the importance of safeguarding workers' interests by providing preferential treatment to their dues in the event of liquidation. This recognition is grounded in the understanding that workers often find themselves in vulnerable positions during insolvency proceedings and need protection. However, the IBC takes a different approach by categorizing all dues, including workers' dues, under the umbrella of operational creditors. This means that in the context of liquidation under the IBC, workers' dues do not receive any preferential treatment compared to secured financial creditors. This categorization can create a conflict of interest between the provisions of the Companies Act and the IBC, potentially compromising the interests of the workers. Now, the conflict of interest arises from the need to strike a balance between the rights of the workers and the overarching objective of the insolvency proceedings, which is to ensure a fair and equitable distribution of assets among all stakeholders. Now, while the IBC aims to streamline the insolvency process and provide a level playing field for all creditors, the preferential treatment according to workers' dues under the Companies Act recognizes their unique position and the need to protect their livelihoods. Now, what are the observations of the Honorable Supreme Court? The Honorable Supreme Court denied the plea to declare Section 327(7) of the Companies Act 2013 arbitrary and in violation of Article 21 of the Constitution. The applications come on the heels of a Supreme Court decision ordering Moser Baer's dissolution. The NCLT held in 2019 that Provident Fund, Pension, and Gratuity Fund do not form part of a corporate debtor's liquidation estate. The petitioners argued that Clause 19A of the 11th schedule of the IBC be declared unreasonable and in violation of Article 14 of the Indian Constitution because it inserts subsection 7 in Section 327 of the Companies Act 2013, which places an obligatory bar on the application of Sections 326 and 327 of the Companies Act 2013 to liquidation proceedings under the IBC. They requested in court that workers' dues be settled in accordance with the reasonable criteria outlined in Section 326, even in the case of liquidation under the IBC. While upholding the validity of the provision, the bench stated, I quote, "We will not set aside the legislation solely on the ground that some or marginal sacrifice is to be made by the workers," I unquote. Certain sacrifices are required from all parties, especially the workers, for the revival and rehabilitation of the companies. Now, in the case of insolvent companies, everyone, including secured creditors and the central and state governments, must make sacrifices for the sake of survival and regeneration, the bench stated. The bench further stated that the waterfall mechanism is based on a structured mathematical formula, and the hierarchy is created in terms of payment of debts in order of priority with several qualifications, and striking down any of the provisions or rearranging the hierarchy in the waterfall mechanism may lead to several trips and disrupt the working of the equilibrium as a whole, resulting in instability. So we conclude that the judgment of the Moser Baer Karamchari Union case upholding the constitutionality of Section 327(7) of the Companies Act carries significant implications. It underscores the court's recognition of the organic evolution of law and the extensive consultative process involved in enacting the IBC Code. The judgment highlights the code's objective of maximizing asset value and balancing stakeholder interests, bringing Indian practices in line with the global standards. Now, in terms of the corporate interests, the case emphasizes the importance of a comprehensive and time-bound framework for insolvency resolution. The court recognizes the need to protect the rights of both secured creditors and workmen, maintaining a delicate balance between the two. So, friends, we see that the Honorable Court has protected the interests of the workmen while also safeguarding the sanctity of the law and upholding the various provisions for balancing the rights of the stakeholders. So, friends, I trust that you find this both enlightening as well as engaging. So for further insights into such key judgments under the IBC, please like this video and subscribe to my YouTube channel. So friends, thank you for being with me here today. This is Deepika B. Prasad signing off. We'll catch you in the next case. Thank you.